Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. For the U.S. vaping industry, it's been a long and punishing journey navigating the U.S. Food and Drug Administration's regulation of nicotine vaping products. But now, the nightmare may finally be nearing its end. The Supreme Court of the United States has agreed to hear a case we've covered many times on RegWatch, a case that challenges the FDA's pre-market tobacco application process, which was deemed arbitrary and capricious by the Fifth Circuit Court of Appeals. With the FDA rejecting 99% of applications and issuing countless marketing denial orders, the industry's future is hanging by a thread. Now, with SCOTUS stepping in, especially after recent rulings limiting the power of federal agencies, there's renewed hope that the U.S. vaping industry just might survive. And joining us today to break down the details of this landmark SCOTUS hearing is longtime guest and RegWatch's legal soothsayer, Greg Troutman. Greg, welcome back on the show.
Thanks for having me back again.
First, I should just make a quick comment about my voice. It's a bit rough. I developed a bit of a polyp on a vocal cord, and it's been a real challenge shaking it, but I press on. Greg, you're one of the lawyers submitting an amicus brief in this pivotal case. Just how significant is this moment for the industry?
Extremely. It's a make or break moment for this industry. And when I say that, literally this industry, its fate rests in the balance. If we win this case in whole or part, it's going to be a life vest for the industry. If the Supreme Court finds that FDA is right, I don't know where this industry goes going forward.
So walk us quickly how we got here, because we've covered it in depth and we will certainly cover the issues below. But this was a case, a Triton case that moved to SCOTUS?
This was one of the many cases that got filed back in September, October 2021. We've been going at this now for 3 years. In the various appellate courts after FDA started issuing its serial marketing denials. And this was the case of Wages and White Line Distribution, Triton, and Vapetasia, two different companies, filed petitions for review in the Fifth Circuit Court of Appeals in New Orleans. And that court hears appeals that emanate out of Texas, Louisiana, and Mississippi. Both Triton and Vapetasia were Texas companies. So that's why we ended up in the Fifth Circuit. The case was argued in January of 23. We got a ruling in July of last year, a 2-to-1 ruling for FDA. Triton and Vapetasia filed for what's called en banc review, the full 16-judge court to review the case. And a majority of the judges have to agree to do that, and a majority did. The decision came out, it was argued in January of 2022. The decision came out in July of 2022, applied for rehearing, was granted. It was reheard in May of 2023. Then the en banc ruling 10-6 came out January 3rd, 2024, reversing the initial panel and ruling that FDA had acted arbitrarily for a number of reasons with regard to Triton and Vapetasia, vacated their marketing denials and sent those applications back to FDA. FDA then, through the Solicitor General's office, filed for certiorari with the Supreme Court, which it granted on July 2nd.
So it's actually the FDA that has brought this case to the Supreme Court.
Yes, and as a sidelight, there are two other cases. Magellan, which was a big company out of New York, has a case out of the Second Circuit that they lost. And then Lotus, which is an Idaho company, had a case in the Ninth Circuit, which they lost. Both Magellan and Lotus had also sought cert in the Supreme Court on their losses, as well as not Liquid Labs, but Logic out of the Third Circuit, which is represented by a different law firm. Those three cases are pending before SCOTUS. And what's going to happen is whatever the outcome of Triton is will dictate those cases. So what that means is if we win Triton, we will then by default win Magellan, Logic, Lotus. So we would get really 4 wins in one.
So let's talk about quickly what could be the impact if the industry does not prevail with SCOTUS.
if the industry does not prevail with SCOTUS, barring Congress stepping in and reforming the PMTA process, I frankly don't see how the industry survives. I mean, the open system industry is barely hanging on right now anyway. And I think this puts it away. This is the knockout blow if the industry loses. But I don't think that's going to happen, Brent. I really don't. You call me the soothsayer. Part of being a soothsayer is you read the tea leaves and you look at what the Supreme Court has been doing this past term, which made some major statements in administrative law, and some of its more recent terms where it started on this trajectory. And it is on a trajectory to bring, to rein in, to bring a wrecking ball, whatever you want to call it, to the agencies. I'm not the only one saying this. If you look at prognosticators, if you look at people who follow the Supreme Court and write blogs and do that, the article I sent you earlier today discusses that. That it seems that there are some issues that are left remaining that the court is going to eventually address. And it just so happens that the Triton case presents possible two of those situations that they might want to take up.
So, Greg, one of those major things that you were talking about in terms of decisions that SCOTUS has made recently that could be helpful was overturning Chevron Deference, which was the Loper decision. I want to talk about a couple of these key legal matters up at the top. So when we're discussing the specifics about vaping, we'll have already done that. So tell us about Chevron Deference. How big of a blow was that to the administrative state? And did you ever think that it could get overturned?
What Chevron was a 1984 case, Chevron versus the National Defense Resources Council. Chevron was a case involving the deference that an agency is supposed to get from a reviewing court when it is interpreting a vague or ambiguous statute. Well, most statutes that an agency interprets are vague and ambiguous because what Congress does is it passes a skeleton and it leaves it to the agencies to fill in the blanks. So many congressional enactments are vague, fall into this format. Give you an example. Appropriate for protection of public health, which is the metric in the Tobacco Control Act, is one such vague and ambiguous phrase. Congress has left it to FDA to determine what appropriate for protection of public health means. Courts had to reflexively defer to what an agency interpreted a statute that was under its control. It didn't have to be the best interpretation. It only had to be a reasonable interpretation. Well, you could have multiple interpretations of something that's ambiguous. And so long as the court has to defer to what the agency says, the agency is going to win most of the time. What Loper did, and just for clarification, I was on brief in an amicus with Keller Heckman for the vape industry in Loper. So what Loper said is that we're going to go back to an earlier standard that was similar to what was applied in another case back in the 1940s, and it gives less deference. And it's basically the court now gets to look behind the curtain, look under the hood, much as the Fifth Circuit did in Triton. We got the Fifth Circuit decision really was a look under the hood or look behind the curtain of what FDA did. And you see, if FDA had been given deference like it was in the other appellate courts, it would have won in Triton. But because the court looked behind the curtain, sort of gave us a preview of how Loper should function, we now have all of these reasons that FDA didn't live up to what it was supposed to do or what it said it was going to do. And that was arbitrary.
If Chevron Deference hadn't been overturned, it's really hard to get over that hurdle because it's kind of like the agency says so, so it is so. And now it's not that the agency says so, and it is so anymore. The court gets a say.
The court gets the final say. And what the Supreme Court ruled is that on issues of law and the interpretation of a statute is a legal question. That on legal questions, courts get to decide those, not agencies. Like in the FDA context, what's appropriate for the protection of public health? Well, they have to consider the benefits and risks to smokers and users and non-users of tobacco across the population as a whole. Well, FDA never has told the industry, it says we want you to compare your flavored products to tobacco flavored products as a function of smoking cessation, but they never told us how many smokers have to quit. What's the baseline? There are no metrics. And what's shocking, and actually I think very tone deaf before the court today, is FDA's arguments that they actually say, we don't have to tell you what these metrics are because you're applying for application to do something that you're not legally entitled to do. Yeah, well, people that are seeking Social Security, veterans benefits, they're applying to the government for a benefit. How's that that's tone deaf, absolutely tone deaf, given the recent bend of this court to rein in agencies coming in hot and saying, not only are you wrong, we should get to do this even more extreme. I don't think it's going to be very well received.
So, Greg, and there are other Supreme Court precedents that bolster agency power, which have not been overturned. One of them is called Chenery II. Explain that.
Chenery II. And the reason it's called Chenery II is there is a Chenery I, which was 4 years earlier. And those are two cases involving the Securities and Exchange Commission and their attempts to regulate utilities, local utilities back in the 1940s. And in the first Chenery case, the SEC tried to adopt a rule through the adjudication process. Although what the applicant did, there was no law that said you can't do what they did. And the Supreme Court sent the case back to FDA in Chenery I and to SEC and said, SEC, you can't do what you tried to do because you didn't have a rule that said they couldn't do this. So what SEC did is on the second pass, it made up a rule and applied it retroactively. And in Chenery II, the Supreme Court said, well, we prefer that agencies go through the formal rulemaking process. And what that means is, under the Administrative Procedure Act, an agency, when it's a major policy initiative, has to publish public notice in the Federal Register, has to go through a public notice and comment period. They have to take public comments. They have to distill those comments. And in many cases, public comments will drive what a final rule or regulation looks like. They have to accord and have to explain why they're accepting or not accepting the public comments. That is a process that takes anywhere from a year to 2 years. The DEMAND rule in 2014, when it was proposed in April of 2014, it wasn't adopted until May of 2016, so 25 months. It's a cumbersome process. What FDA has done and trying to do is adopt a product standard, which the Tobacco Control Act says has to go through notice and comment rulemaking. And it is a product standard because it involves the constituents or ingredients of a product, which includes flavorings by definition. And FDA is saying we don't have to go through that process. We can create our own product standard to require flavored products to fill heightened requirements through the adjudication process of PMTAs. And they rely on Chenery II for cover. So one of the questions the Supreme Court could take up is Chenery still good law in light of the recent precedents, or is it to be restricted to emergency one-off kind of situations, not used for broad policy making for an entire industry, for a global circumstance instead of a one-off emergency? And I can see why agencies need to have authority on an emergency basis. Like during COVID, for instance, agencies needed to be able to do things on an emergency basis that would go away as soon as COVID was over. This is not what we've got here. So I could see the court greatly rolling back Chenery or maybe eliminating Chenery as a concept that's viable. That would be big because the agencies use this quite often. And I know that there are some people on the right that want to see the Federalist Society for sure wants to see Chenery II go away. So we may be handing them that victory.
And I think it's important to just really highlight here that under Chenery II, it generally provides blanket authorization for agencies to make law through either adjudication or rulemaking. As you were saying, it was rulemaking, but
Right.
the adjudication process is where FDA seems to be making a lot of law, and that's really where the problem lies. So, Greg, let's dive into the Amicus Brief that you and Azim Chowdhury and Eric Goding have been putting together on behalf of the U.S. open system flavored vapor products industry. Open systems is really the key point there, and flavors. There are four main arguments being made in your brief. Here is the first. FDA ignored Congress's clearly mandated process for adopting a tobacco product standard when implementing its de facto ban on flavored vaping products.
Well, that's kind of what we were just talking about. That's the Chenery argument, is that the Tobacco Control Act lays out a specific way that FDA has to go about adopting a product standard. Congress adopted a product standard in the TCA when it banned the addition of flavorings to cigarettes back in 2009. It then allowed FDA to adopt further product standards, but it requires notice and comment rulemaking to do so. So the question is, does FDA, are they constrained to follow that? Because the statute specifically says you have to do notice and comment rulemaking on this issue. Does that give FDA leeway to apply Chenery?
Or does it force them to actually have to do the proper public notice and comment for rulemaking process? They have not seemed to want to make a product standard rule with regards to flavor, which if they did that, it would at least be a little fairer.
Well, and here's the problem they're going to run into and this is why I think they're picking to use Chenery, is that when the deeming rule was first proposed in 2014, it included a ban on the addition of all characterizing flavors to all tobacco products. That not only, but it's part of the notice and comment process is it also has to go through another phase that it's from the Regulatory Flexibility Act, is that regulation or rule has to be reviewed and approved by the Office of Management and Budget within the White House. What happened was OMB struck out and would not give approval to the deeming rule if it included the language about the ban on flavorings. That was stricken out. So FDA knows it is probably not going to be able to get a flavor standard that would ban flavors through the rulemaking process. So it's trying to do indirectly what it cannot accomplish directly.
Do you believe that it was a preordained plan to create this situation where it's this de facto ban on flavors?
I think there was an eye towards that, but I think there's a bigger thing going on here, Brent, is that FDA miscalculated a lot in this case. And this goes back to 2014 when the deeming rule was first being proposed with regard to the number of applications, number of PMTAs they thought they were going to receive. They said in their fiscal analysis no more than 2,500. They set up all of the deadlines, would have made sense for no more than 2,500 applications. You could get through those pretty quickly. But when you get 6.7 million applications, FDA was nowhere prepared. And I think once FDA started enrolling, they jumped to unroll this in 2016, right before Obama leaves office. Remember, this was in May of 2016. He's going to leave office in January of 2017. So this was political to get this rule out. Because FDA miscalculated so badly, this should have been a decade-long process to roll out, because there's all sorts of internal rulemaking that has to take place as far as being ready for these PMTAs. And FDA was nowhere going to be near ready for these PMTAs. And once they realized 3 or 4 months into this process, whoa, we got a lot more here than what we thought, they started scrambling and trying to, on the fly, move things down the road, extend deadlines, kick things down the road, delay things. And they didn't go through notice and comment rulemaking when they tried to change the PMTA date by 4 or 5 years. That got them in trouble, got them sued, and a court put a hard stop on it and said, here's where your date's going to be. Well, they weren't ready for getting what they got. And they had a year to adjudicate everything. What they did was essentially came up with a way to eliminate a lot of these products very quickly and efficiently. They did it, we've got documentation from them that says, we're doing this for the sake of efficiency. We've got internal memos, by the way, that show that they didn't even read the marketing plans that they said pre-PMTA were so important. And part of FDA's problem in this case is all of its pre-PMTA guidance talked about the distinction between open and closed systems as it pertains to their youth risks of access and use. FDA has really been fixated on youth access. And unfortunately, FDA has applied a blanket presumption that all flavored vaping products are equally risky to youth as far as an initiation and appeal. They know that's not true because their own guidance tells us it's not true. And if you remember back to January 2020, when they adopted the guidance for involving the flavored pod products, the flavored jewel pods, they recognized that kids were using the closed system products and the kids really weren't using open system. So what FDA should have done in its regulatory process was to have two processes. One, they look at open system differently. They look at the risk differently than they do, and the comparative efficacy standard would be perfectly suited for closed system products. It is not suited for open system products. It has no application. It's kind of like you get a brand new car, and brand new cars are known to be very fuel efficient and very environmental friendly. The city requires you to get your car emissions tested, even though they know you're not going to have any emissions that even remotely approach their standards. But they make you do it anyway. They want your money. Is that arbitrary? You know, when you don't regulate based on the known risks, when you say risks is what we're adverse to, but you don't regulate based on the known risks, that is arbitrary. And that's the main argument. The main focus of this industry's case is FDA needs to regulate distinctively based on what the actual risks are.
Let me ask you, just a couple of weeks ago, FDA came out and with a release that says that U.S. Youth vaping drops to its lowest level in a decade. I mean, it's a pretty astonishing admission. Is something like this at all could affect, or even is it germane to the SCOTUS process?
I believe so. And I addressed that in the Amicus Brief, is that since FDA issued these blanket marketing denials in 2021, the science has only gotten stronger. And I use the term more robust to use their parlance. The science has gotten more robust about the benefits of flavors when it comes to adult cessation. And some of the studies even talk about, and it was one of the studies even talked about, that cities and states that banned, it's the Abigail Friedman study from Yale, that cities and states that banned flavored vaping products over the number of years, how much their smoking rates have gone up, especially among the brands that youths tend to prefer. So it's had a boomerang effect. Again, if you have a government policy, an agency policy, and your goal is to do A, B, and C, and your goal does everything but A, B, and C, and does contrary to A, B, and C, that by definition is an arbitrary process.
Okay, let's move on to the second argument in the brief, Greg. This case is tailor-made for review under LOPR because FDA must now justify its many deviations from permissible regulatory practices and not expect automatic deference. So from what I understand from the brief is that FDA failed to articulate specific definitions or metrics to govern the pre-market tobacco applications.
Among other things. It's noteworthy. Loper came out, was issued by the Supreme Court on June 29th. It issued the order granting certiorari in the Triton Vaptasia case on July 2nd. So just a couple days later, we get this. I think they probably had Loper in mind when they granted cert in this case. This is going to be one of the reason why I think it's important. It's going to be one of the first administrative law cases the Supreme Court takes up post Loper. So this is, I think, going to give us some idea of how Loper will be interpreted down the road. And I think other courts will look at this as a guidepost. The reason why this case is important under Loper is that now that the Supreme Court can look behind the curtain, look under the hood, and see exactly what FDA did and write its own critique about it. And if the Supreme Court is as troubled as the Fifth Circuit was, then I think that's going to drive where their decision goes. That's why, being the first case coming out under Loper, this case is going to have, I think, some precedential tail to it.
Meaning that what happens here could affect other cases, other agencies across many different industries.
Correct.
Okay, Greg, here's the third argument being made in the brief, and it's a multi-part argument. You're stating FDA acted arbitrarily by 1, articulating post hoc justifications, 2, failing to provide fair notice of its comparative efficacy standard, 3, changing a substantive position without displaying an awareness of and explaining the change, and 4, ignoring the appellee's reliance interests. Let's go through each one of these points. Greg, where do you want to start?
I'll start with the beginning. And these were the 4 main points that the Fifth Circuit found in its analysis, which it referred to as dizzying. Okay, that's, yeah. Post hoc justifications. What that means is FDA said one thing in its marketing denial order, and the technical project lead that it sent it in conjunction with that it sort of explained the rationale for why it did what it did for Triton and Vaptasia. But the arguments the court made before the Fifth Circuit, the initial panel, were different. They said, well, we really we said we did it for this reason, but we did it really for this reason. They were making things up as they went along. Well, you can't do that in administrative law cases. The agency is bound by what it says was the reason for its decision. And if you make post hoc rationalizations in a court case and you're an agency, that's a recipe for losing. And then FDA came along in the en banc phase and they doubled down on their post hoc rationalizations. So the argument that I'm making is, and I go through the analysis of this, of why it's not valid, why their rationale is not valid. And I conclude with the statement that an agency process should not have to rely on post hoc rationalizations to stand up to scrutiny. A good process doesn't need post hoc rationalizations. And the fact that they're having to rely on them tells you that there's inherent defects in their process and in their reasoning.
The issue when it comes to failing to provide fair notice, that's almost like even before, like that's the all communication issue. So FDA has fallen down on communicating with the industry about the changes in the guidance or the process as it's unfolding.
Correct. And the Supreme Court has a long history of cases that say that agencies have to act fairly with regard to the regulated parties. They have to give fair notice of what they require. And if they change their mind, they then have to give fair notice of that change and explain that change. The agency, and I argue this, is that the agency can always change its mind or change its mindset as its experience evolves in a particular area. FDA says, well, we've had an evolving mindset with regard to the effect of flavors in vaping products. Okay, fine. FDA can have an evolving mindset. It just has to be transparent about that change and give fair notice of when it's going to change a process. It's an example, you're driving down the road and you pass a sign that says speed limit 65 miles an hour. Well, if the speed limit all of a sudden changes back to 55, they got to put a sign up that tells you speed limit's gone down. Fair notice. Same philosophy. here. And what FDA did is, in all of its pre-PMTA guidance, it said, this is how we're going to do things. We view open and closed systems differently. We don't require you to do long-term studies. And part of that was because FDA realized that the industry wasn't going to have time to do them. And because we were in this compressed process that got lengthened and then got compressed again. And everybody's scrambling trying to get together their PMTAs. Well, FDA's scrambling trying to get their process together to review PMTAs. So FDA said, we don't have to do as an industry these long-term studies at this point. We don't expect them now. I think they were going to kick that can down the road. But then when they realized that, oh Lord, we've got to review all of these and we've got a year to do it, then all of a sudden, not having it is a quick way to get rid of them, which is what they decided to do. When they evolved their mindset midstream, and what's worse is they didn't give notice that we've changed our mind, and they didn't give an opportunity to amend PMTs. If FDA would have come along and says, we're now going to require this, and you have until a certain date to get us this study, they probably would have gotten away with that. But by just saying, oh, we've changed our mind, and oh, by the way, we're not going to let you amend, that's where they got a problem.
It's frustrating. You outlined it in the brief, and of course, we covered this in real time. FDA said they would not require long-term scientific studies, then moved the goalposts, requiring long-term scientific studies.
Oh, it's worse than that. It's not just moving the goalposts. It's like moving the field beneath your feet while they're moving the goalposts while you're trying to play the game.
True. And they also placed great emphasis on the marketing plans to demonstrate that these products would not be marketed to youth. Then FDA admitted, as you said, that they never read any of the marketing plans. For the countless products they issued marketing denial orders to. And for me, I'm like, to borrow a Biden term, come on, man. It's labeled a marketing denial, and they never even look at the marketing plans.
And it gets even better, is that the justification that FDA used for not reading the marketing plans is saying, well, the things that have been in all the plans we've seen so far, we've already determined from our experience, these won't work. But ironically, when it improved the Enjoy menthol product here recently, oh, by the way, some of those same marketing plan ideas were things that Vapetasia and Triton had in their marketing plans. So they don't work till they do work, but they don't work for you.
So, Greg, explain the Reliance interests point.
Well, that goes part and parcel. A lot of these arguments dovetail each other. When FDA gave its assurances and all the pre-PMTA guidance, they crafted Reliance interest. The industry relied on those representations and those assurances. That's one of the arguments I make in the brief is it'd be one thing, and because the assurances were vague and ambiguous, you could read them two different ways. You could read them the way FDA's read them. You could read them the way the industry's read them. And what FDA's done is it's saying, industry, we're going to penalize you because you read it the way you didn't read it the way we're reading it, and you're wrong, and we're going to ding you for that. And the court notices that. But the court also says that FDA's proposed interpretation is weakened and undermined by its own actions and certain facts. But I find it ironic that pretty much everybody in the industry that filed PMTAs had the same interpretation. What's the statistical likelihood that was a random occurrence?
Greg, here's the final argument of all your main arguments being made in the brief. The Tobacco Control Act's deeming provision is unconstitutional under the major question doctrine. Greg, what is the major question doctrine, and how does it apply here?
Well, the major question doctrine is sort of an offshoot, a subset of the separation of powers doctrine. Three branches of government, each has their own lane to stay in, and you violate separation of powers if one branch moves over into the lane of the other. Okay. What major question means is that certain policies are so broad, so impactful, that by default, only Congress can make the give authority for an agency to regulate that aspect of whatever. There's been a number of major question cases have come along, and the one in modern times that really got this movement kicked off was a 2000 case, Brown and Williamson, or FDA versus Brown and Williamson. That case got to the Supreme Court as a result of FDA back in the mid 90s got tired of waiting for Congress to regulate tobacco, and that FDA wanted to seize control of regulating tobacco. So it said that nicotine is a drug and cigarettes are a drug delivery device, and it tried to regulate tobacco through the drug pathway. And the Supreme Court said, no, not so fast. And it went through a litany, a historical litany, and discussion about the major historical economic underpinnings that tobacco has in this country's history. And it says that makes it a major question, and that only Congress can adopt the regulatory framework and give FDA authority to regulate tobacco, which that was important. So coming along to 2009, the Tobacco Control Act Congress adopted. And in the Tobacco Control Act, it actually had a provision in the TCA that acknowledged the major question impact of tobacco in the economy. So Congress accepted that this is a major question. It applied the Tobacco Control Act to only 4 subset tobacco products. It knew vaping products were on the market. If you look at all of the debates for the TCA back in 2008, 2009, they discussed vaping products. They knew they were there. They chose not to regulate them. Aside from the 4 subset products, they left all other tobacco products subject to being included in the TCA upon FDA deeming by rule those products to be subject. So what that means is Congress has delegated to FDA the authority to decide the scope of what it's going to regulate. And what my argument is in the major question doctrine is that if it's a major question, regulation of tobacco is a major question, that only Congress can pass the regulatory framework identifying what products are to be regulated is part and parcel of that regulatory framework. And that Congress ignored Brown and Williamson when it included the deeming provision in the Tobacco Control Act. The court, if it so chooses to latch onto this argument, could potentially declare the deeming rule unconstitutional and prevent FDA from regulating until Congress says we're including vape products, cigars, snus, whatever, under the TCA. So it would kick this back to Congress.
Well, that would be something, wouldn't it?
Well, and, the article I sent you this morning about the upcoming Supreme Court term, and they talked about non-delegation as being a hot button issue. This is non-delegation. This is a non-delegation case. It's really going to depend on how far the Supreme Court wants to go. If they want to carve a narrow path and say this is a product standard, FDA has to go back and go through the rulemaking process. If they want to carve a broad path and say the whole process is unconstitutional, they can do what they want. They're the Supreme Court. Either way, I think we're going to get a pretty landmark ruling. I think Chenery is going to get either peel back or go away entirely as part of this process. And they may go as far as saying this whole thing's unconstitutional.
So it really feels that there's the potential here that the U.S. Supreme Court could upturn the entire administrative state.
Well, and the outcome of the election is going to weigh heavily on this too, because if Harris wins, we kind of know what FDA is going to look like. But if Trump wins, imagine the idea of Robert F. Kennedy Jr. running FDA or HHS, which oversees FDA. We could be looking at a whole new ball game here and a whole new view of how these products are to be regulated. Quite frankly, a Supreme Court victory is only the first step in what we've got to do. It's a huge win, We'll celebrate, we'll dance and sing for a little bit, but we got to get to work. If we win in the Supreme Court, we got to get to work quickly, and we need to start actually sowing those seeds now on the way forward. Because let's say narrow scenario, Supreme Court comes back and says it's a product standard. FDA, you got to go through the rulemaking process. That's an 18-month to 2-year process, and it's going to create a regulatory vacuum. Congress is not going to sit back and let that happen. They're going to step in and do something. We need to be working now with members of Congress, educating them, getting a game plan in place to hand them a piece of legislation that we help craft that will be the plan forward.
So if the industry prevails, what happens to all of the other companies that have received MDOs who are not party to this suit?
Well, their MDOs, except for Magellan and Logic and Lotus, which will be dealt with. As I said, if we get 1 win, we'll get 4 wins. Those will then get thrown back to FDA to re-review too, under whatever standard the Supreme Court says is the standard. If the Supreme Court were to reverse or were to say that the deeming rule is unconstitutional, then it's free for all. Everybody's back on the market, and it's like it was before 2016. We're back 2014, 2015, early 2016. At a minimum, everybody that got an MDO will be able to reapply. And oh, by the way, we've had a lot of products come to market over the last 4 years. A lot of disposable products now come to market. If FDA had to receive a second round of PMTAs, they got 6.7 million the last time. What are you looking at this time? 10, 12, maybe 15 million? FDA could literally lose twice in this whole thing. FDA could lose at the Supreme Court and then really lose if we inundate them with PMTAs, which is going to happen. I'm encouraging everybody out there, if you got an MDO in 2021, 2022, whenever, and we win Triton, reapply. If you have a disposable and you haven't filed a PMTA yet for it, and we win Triton, apply. Brent, this is exciting, and it's scary as hell. It's as scary as hell because between us guys, I know how frail the open system industry is right now. Folks are barely holding on. And I'm telling everybody, just hang on a little longer. Hang on a little longer. If you can make it, if you can still be here a year from now, you're going to be in good shape.